This is a special report on the Hidden Killers podcast.
I'm Tony Bruschi. Thanks for joining us. A hearing took place today in the case of the Petito family against the Laundrie family, focusing specifically on the burn after reading letter and some other issues. We're going to take you to the courtroom for that testimony right now.
Judge Chuck Meltz with Laura Kelly. We're here on behalf of Stephen Bertolino, who's also present.
Okay, thank you so much, sir. It's nice to see you as well.
Good afternoon, Your Honor. Matt Luca on behalf of Christopher and Roberta Laundrie.
Okay, nice to see you as well. All right, my understanding here today is that we are noticed for plaintiff's motion to compel responses to plaintiff's third request for production of documents to the defendants, Christopher Laundrie and Roberta Laundrie. That's DIN 124. We are also set for hearing today, excuse me, for a defendant's motion for protective order and affidavit in support, and that is DIN 104 and 105. And we are also set for hearing today on defendant Laundrie's motion to dismiss the second amended complaint, which is DIN 91, and defendant Bertolino's motion to dismiss the second amended complaint, DIN number 98. Am I at all off on any of that?
No, Your Honor, that's everything.
Are there any others that we thought we were going to hear that are not, that I didn't list?
If there are, I'll be surprised.
Okay, great.
No, Your Honor.
Fantastic. Okay. I'm going to ask you all's opinion on which we believe is best to be handled in what order.
I think the motions to dismiss should be heard first, Your Honor.
I would agree, Judge.
Okay, wonderful. And which motion to dismiss do we wish to hear first?
Judge, Mr. Luca and I flipped a coin, so I will go first on behalf of Mr. Bertolino, if that's acceptable to everyone.
That is acceptable to me, if you'd like to continue, sir.
Thank you.
Great.
May it please the court.
Yes, sir.
Judge, once again, Chuck Meltz and Laura Kelly, on behalf of Mr. Bertolino. We're here today on the motion to dismiss the second amended complaint as it relates to Mr. Bertolino. Mr. Bertolino, as the court's aware, was added as a defendant in the second amended complaint. The counts against him appear at counts 3 and 6. Although the counts are not labeled, it's clear from the history of this case and the nature of the allegations that the counts are premised on intentional infliction of emotional distress. And because of that, they derive from the restatement of tort, section 46, which sets forth the various requirements for that count. Various Florida cases have interpreted that, all of which we'll discuss. Understanding we are here on a motion to dismiss, the way I plan to argue this is really to focus on the second amended complaint, as the court must do. Understand that the court must accept the allegations of the second amended complaint as pled. However, when we go through the second amended complaint, I believe what we're going to be able to show is that those allegations fail as a matter of law and do not establish a cause of action for intentional infliction of emotional distress. We will also focus on the purported language that's at issue, Mr. Bertolino's comments as cited within the second amended complaint, which our position again is do not support a claim for intentional infliction of emotional distress. We'll talk about the different cases that have interpreted this particular cause of action, look at the illustrations that are in the restatement, all of which are informative as to what does and does not reach the level of intentional infliction of emotional distress. And our position at the end is going to be that the entire cause of action against Mr. Bertolino is due to be dismissed. And if for some reason the court doesn't get that far, there are certainly parts of the cause of action which clearly cannot be sustained, irrespective of any other argument set forth. I would also add, Your Honor, that we're mindful of the history of this case. And in making the argument today, we will absolutely cite to the cases that Judge Carroll cited to in his last ruling. The Liberty Mutual case in particular is very informative, and also talk about some of the commentary from Judge Carroll that, again, previously dates our time in the case. So, Your Honor, just to start off, before we dive into the second amendment complaint, it's been around for a long time, but intentional infliction of emotional distress is a infrequently pled cause of action. It's a cause of action that does not have a great track record in terms of what constitutes it or not. But what is abundantly clear from both the restatement and the cases that interpret it is that the threshold for bringing it is extraordinarily high. And so as the restatement itself says, it's not been enough that the defendant has acted with an intent which is tortious or even criminal, or that he has acted to inflict emotional distress, or even that his conduct has been characterized by malice or a degree of aggravation which would entitle the plaintiff to punitive damages for another tort. Liability has been found only where the conduct has been so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency and to be regarded as atrocious and utterly intolerable in a civilized community. Generally, the case is one which the recitation of the facts to an average member of the community would arouse his resentment against the actor and lead him to exclaim, outrageous. So that is the threshold for pleading intentional infliction of emotional distress. So with that said, Judge, I would like to focus on the Second Amended complaint. And if you have our binder, it's tab C, which is where it appears. If you're looking at it electronically, I'm sure you have a way to pull it up. But let me know when you're there, and I'll move along.
I have it in front of me because I printed it, but I'm trying to find tab C here because it looks like your...
We have a small binder and a big binder. The big binder is the case law and some other materials. The small binder is the motions with the amended complaints.
I found it.
Excellent. So, Your Honor, the Second Amended complaint is a relatively short pleading that contains 6 counts. There are 2 distinct plaintiffs, Mr. Petito and Ms. Schmidt, and there are 3 distinct defendants, Mr. and Ms. Laundrie and Mr. Bertolino. Mr. Bertolino is introduced in paragraph 7 and 8, where he's identified as a lawyer who's licensed to practice in the state of New York, and then in paragraph 8, that at all times relevant to within the cause of action, Mr. Bertolino was acting as an agent for Christopher Laundrie and Roberta Laundrie. So the first alleged fact within the 4 corners of the complaint is that my client, Mr. Bertolino, the purported actor in the intentional infliction of emotional distress, is in a unique capacity compared to most who have come under this cause of action. He was an attorney providing legal advice and guidance and representing his clients. There's some additional information provided, Judge, but when we get to paragraph 20, this is where the background or the factual background starts to really come in. In paragraph 20, there's an allegation that on or about August 28, 2021, Brian Laundrie advised his parents, Christopher Laundrie and Roberta Laundrie, that he had murdered Gabrielle Petito. Again, it's an allegation in the complaint. Clearly, the plaintiffs can't have any firsthand knowledge of that, but they pled it. The court's bound by it for purposes of a motion to dismiss. It then goes on to say in paragraph 24, from August 27, 2021 until September 19, 2021, when Gabrielle Petito's remains were found at the Spread Creek dispersed camping area in Wyoming, plaintiffs were extremely distraught and were attempting to locate Gabrielle Petito. And, Your Honor, this is where it's important to give our first real focus to what's in the Second Amended complaint. Traditionally, causes of action for intentional infliction of emotional distress require the actor to trigger the emotional distress. The actor says harsh words. The actor threatens physical violence. The actor embarrasses or humiliates a target with intent and malice. In this case, Your Honor, by the own pleading, the plaintiffs allege that as of August 27, 2021, they were rightfully so and understandably extremely distraught. And that becomes important, Judge Brewer, because that level of distress predates any conduct of Mr. Bertolino in this case. So as a starting point, again, four corners of the complaint, the extreme emotional distress, which is the ultimate byproduct of where we head to, predates Mr. Bertolino's involvement. Paragraph 25 then talks about the Laundrie family purportedly going on a family vacation. Paragraph 27, this is a reference to Mr. Bertolino, which really are few and far between in the second amended complaint. It discusses that on September 13, 2021, Brian Laundrie left his home. Mr. Bertolino gave a press conference or interview a month or so later and described that he was grieving. I'm not sure that has a particular relevance to the case, but it's just one of the few paragraphs where Mr. Bertolino's statement or conduct's actually referenced. Where we get to paragraph 28, this is where the first purported fact setting forth a cause of action for intentional infliction of emotional distress against Mr. Bertolino is alleged. And it says on September 14, 2021, with full knowledge that Gabby Petito had been murdered by Brian Laundrie, and it is believed that they knew the whereabouts of her body, Stephen Bertolino, on behalf of Christopher Laundrie and Roberta Laundrie, issued the following statement. And so again, if we back up to paragraph 24, the emotional distress started on August 27th. Now in paragraph 28, we're at September 14, and this is the first purported act or conduct of Mr. Bertolino. Procedurally, Judge, paragraph 28 only contains a portion of Mr. Bertolino's statement that day. Based on discussions with Mr. Riley, there's no objection to the entire statement coming in. It's actually Exhibit A to our motion to dismiss.
I saw the stipulation as to that. Okay.
Thank you, Your Honor. So I'll read the entire statement, understanding that there's only a portion of it in the second amended complaint, but given the stipulation, it's all covered within the four corners at this time.
Understood.
So on September 14, 2021, Mr. Bertolino's office issues a statement, R.E. Ms. Petito. It says, statement from counsel from the Laundrie family. This is understandably an extremely difficult time for both the Petito family and the Laundrie family. So let's look at that first sentence. There's no objective way. There's no context or circumstance. There's no interpretation that can be given to that which would ever rise to the level of intentional infliction of emotional distress. The next paragraph. It is our understanding that a search has been organized for Miss Petito in or near Grand Teton National Park in Wyoming. On behalf of the Laundrie family, it is our hope that the search for Miss Petito is successful and that Miss Petito is reunited with her family. And again, Your Honor, there is no interpretation or anything else that you could apply to that statement which in any way makes it actionable under this particular cause of action. And then finally, it concludes, on the advice of counsel, the Laundrie family is remaining in the background at this juncture and will have no further comment. Before proceeding further, Judge, again, sticking to what's been pled here. In every instance of intentional infliction of emotional distress, the actor has targeted the recipient. In every case that's cited, in every illustration, in the restatement, there's always been a target, for lack of a better term, when it comes to words. There are other examples of intentional infliction of emotional distress. Showing autopsy photos was one of the cases that Judge Carroll cited too. But other than that very rare exception, there's all direct communications. And the reason there's direct communications, Judge, is because the actor has to intend the emotional distress to occur. There's intent, there's malice, and then there's recklessness. But in either of those or all of those scenarios, it's linear. The actor is doing something ultimately targeted towards the recipient of the conduct. Here, again, just sticking to the Second Amendment complaint, what's been alleged is that the Laundrie's attorney, Mr. Bertolino, acting in that capacity, put out a press statement to the general public at large. And no doubt an argument can be made that Ms. Schmidt and Mr. Petito had access to it or reviewed it or read it or heard it. But in terms of the intent, in terms of meeting that high standard of the restatement, which is so high that even criminal conduct doesn't satisfy it, we have a lawyer for a client who's issuing a public statement that in and of itself is inactionable and totally appropriate. Again, what's within the four corners of the complaint. Paragraph 29, which now interprets that statement, alleges that for the Laundries and Stephen Bertolino to express their hope that Ms. Petito was located and reunited with their family at a time where they knew she had been murdered by Brian Laundrie was beyond outrageous. And again, that's an allegation. It's pled, and the court has to accept it, whether or not it's true. With that said, though, Judge, to express hope, there is not an example in the restatement, there's not a case, there's not a commentary, there's not a law review article, there's not a single situation which has preceded us here today before you in which someone expressing a hope, let alone an attorney, let alone in a general sense and not even a direct communication, there's not a single case which suggests that expressing a hope, no matter what the circumstances, could be considered intentional infliction of emotional distress. Furthermore, Judge, as we know from paragraph 24, the emotional distress already occurred. And what's not in the complaint is that the statement of September 14, 2021 actually caused emotional distress. So when we think about the elements of the cause of action, we first have to have the statement or the conduct, then it has to legally cause severe emotional distress. Second Amendment complaint alleges that the plaintiffs, Ms. Schmidt and Mr. Petito, were already severely distressed. It describes the statement on September 14, 2021, and then it does not allege that it caused severe emotional distress. It discusses purported ill will by Mr. Bertolino in making the statement. Without facts, it attempts to paint it with malice. Without motive, it attempts to paint it as improper, but it doesn't actually link it to causing anything. Paragraph 30 and paragraph 31 talk about the dissemination of it. They're really jurisdictional in nature. I presume there was a concern that there might be a personal jurisdiction defense, which we did not raise, but that's really the thrust of those counts or those paragraphs. Same for paragraph 34, talks about activity within the state of Florida. Paragraph 35 is interesting, Judge, because paragraph 35 talks about a letter on behalf of Ms. Petito's family on September 16, 2021, not to my client, but according to the Second Amendment complaint to the Laundries, in which they are asking for information about their daughter. Paragraph 36, it talks about, despite the fact that Joseph Petito and Nicole Schmidt implored Christopher Laundrie and Roberta Laundrie to tell them if their daughter was alive, and if she was not, where her remains were located, Christopher Laundrie and Roberta Laundrie refused to respond to either Joseph Petito or Nicole Schmidt. Your Honor, again, Judge Carroll talked about that concept, the concept of inaction or not responding last time, although while it was in the body of his order, it didn't actually make it to the ruling, which we'll talk about in a second. But paragraph 36 is not actually directed to Mr. Bertolino, so there would be no obligation for Mr. Bertolino to respond to the letter, understanding there was no obligation of anyone to respond to the letter in the first place. Paragraph 37, while Joseph Petito and Nicole Schmidt were desperately searching for information concerning their daughter, Christopher Laundrie, Roberta Laundrie, and Stephen Bertolino were keeping the whereabouts of Brian Laundrie secret and it is believed they were making arrangements for him to leave the country. Again, no facts to support that. It's an allegation. True or untrue, the court has to accept it. Paragraph 38, Ms. Petito's remains were discovered on September 19. Also at that time, Judge, Mr. Bertolino issued another statement. The news about Gabby Petito is heartbreaking. The Laundrie family prays for Gabby and her family. That's the second Bertolino statement described in the Second Amendment complaint. And before proceeding further with that, as the court knows from our motion to dismiss, Mr. Bertolino is being sued for offering hopes and prayers. And hope is definitely something you can't get sued for, and prayer certainly isn't. And again, as of September 19, 2021, a statement by Mr. Bertolino after the fact that the Laundrie family was praying for Gabby and her family definitionally cannot be actionable as a cause of action for intentional infliction of emotional distress. So now we're up to paragraph 39, and the court's basically heard virtually the entire factual predicate. Whatever facts existed, whatever facts were put into the universe to support these claims, we've covered them. And paragraph 39 then tries to tie in causation for the first time. So remember, we don't really have a causal tie to the September 14th statement. There is no causal tie to the September 19th statement. But what paragraph 39 does is it essentially makes what I would call a refusal to disclose argument that's really separate and independent from the two statements I just read. Paragraph 39 says, Christopher Laundrie, Roberta Laundrie, and Stephen Bertolino knew of the mental suffering and anguish of Joseph Petito and Nicole Schmidt in not knowing the well-being or location of their daughter, and further knew that such mental suffering and anguish increased each day that Gabrielle Petito was missing. Christopher Laundrie, Roberta Laundrie, and Stephen Bertolino further knew, and this is the key part, that they could prevent such additional mental suffering and anguish of Joseph Petito and Nicole Schmidt by disclosing what they knew about the well-being and location of the remains of Gabrielle Petito, yet they repeatedly refused to do so. So we have the actual conduct by Mr. Bertolino. Again, both statements, not targeted, not specific to the family, general in nature, made on behalf of parents who themselves were in an extraordinarily difficult situation. Some of the case law talks about the mental stresses that are on the parties. Clearly, the Laundries had those mental stresses as well. But where the prior paragraphs talk about actions, paragraph 39 essentially says, Mr. Bertolino and the Laundries, Mr. Luca, I'm sure we'll discuss this, what we're suing you for is for not stopping the emotional distress, not causing it, but not stopping it. We started experiencing it much earlier in time, and you didn't stop it earlier by telling us the status of our daughter and where her body was. And again, Judge, for purposes of a motion to dismiss, whether or not any of this is factually correct, the court must accept it as true. So that's what we're dealing with. There is no cause of action for intentional infliction of emotional distress for not stopping it. There's a cause of action for causing it under incredibly severe and extreme circumstances, but there's no cause of action for not stopping it. And paragraph 39 is attempting to do just that. It's making allegations that because of inaction, not because of action, but because of inaction, the emotional distress that had been ongoing since August 27, 2021 wasn't stopped earlier. And Judge, with all due respect, that's just not a cause of action that's recognized under Florida law. It's not a cause of action that has passed grace by the Supreme Court or any of the appellate courts. It's not a cause of action that's described in the restatement. Second, it's not a cause of action that's identified in any treatise or law review article that we came across, but that's the cause of action in this case. And the only time, by the way, Judge, where it alleges that anyone acted with malice or great indifference is right after that. Right after they refused to disclose, it says, Christopher Laundrie, Roberta Laundrie, and Stephen Bertolino acted with malice or great indifference to the rights of Joseph Petito and Nicole Schmidt. Not with the September 14th statement, not with the September 19th statement, but with this concept of not disclosing something that they purportedly knew. 1 through 39, Judge, that is all the alleged facts that this court has to work with. Paragraph 40 then basically sets forth what the alleged wrongful conduct is. To briefly jump ahead, when you go to count 3, which is against Mr. Bertolino, and you go to count 6, which is against Mr. Bertolino, they consist of 2 paragraphs. Basically, we incorporate paragraphs 1 through 40, and then Mr. Bertolino, as a direct and proximate result of the willfulness and maliciousness of Mr. Bertolino, and then they say caused damages. So again, the actual counts themselves, which don't have a title, which don't say they're for intentional infliction of emotional distress, which don't themselves identify what the purported wrongful conduct is within the counts. They're silent on that. So you have to go to paragraph 40 and piece paragraph 40 into counts 3 and 6. Paragraph 40 is a commingled count, which is obvious when we get to the A, B, C, D, E, and F part, because it essentially describes conduct for Christopher Laundrie, Roberta Laundrie, and Stephen Bertolino as if all of them were acting in an identical manner. But nonetheless, what are the causes of action in this case, or what are the components that are alleged for intentional infliction of emotional distress? 40A, failing to advise the plaintiffs that Gabrielle Petito was deceased. So again, a failure to take action, a failure to disclose count. Again, as discussed by Judge Carroll in his order, there is no case law to support that. There's no argument that can be made to support that. Judge Carroll's comment was that if those were the only counts, the entire matter would have been dismissed. But yet in the order just said denied. And this is one of the difficulties with the way this case is pled. It really should be one count for each purported act of intentional infliction of emotional distress, because then that way the court could determine as a gatekeeper, does this count stay or not? And then if for some reason it stayed for summary judgment purposes, we could say, well, count 1, which is the failure to advise, here's our motion on that. Because the actual counts don't describe the wrongful conduct, and because paragraph 40 just lists it as an A through F, it does make it difficult to manage in terms of issuing orders and approaching the pleadings. But in any event, we're treating it as if A, B, C, D, E, and F are all individual or separate and distinct allegations of intentional infliction of emotional distress, because that's how they're described. But in any event, paragraph 40A, failure to advise. Paragraph 40B, failing to disclose to the plaintiffs the location of Gabrielle Petito's body. Again, another allegation of inaction, not an allegation of conduct that was intentional or directed, but simply inaction, discussed by Judge Carroll last time. Paragraph 40C, taking a family vacation. Clearly that can have nothing to do with Mr. Bertolino, but again, because of the way paragraph 40 is pled, it applies to him, even though obviously it can't. Paragraph 40D, blocking access to cell phones. Again, that one can't apply to Mr. Bertolino. 40E and F. This is the September 14th statement of hope in 40E. Paragraph 40F. This is the September 19 prayers after Ms. Petito's remains were discovered. And Judge, that is the entirety of the facts and the theories and the allegations and the links So linking allegations to conduct, linking conduct to causation, linking causation to damages, which is what's supposed to happen in the Second Amendment complaint. Those links are just not here. And so without going beyond the four corners of the complaint, on both sides, because obviously Mr. Riley can't stand up and fill in the blanks. They're either in the Second Amendment complaint or they're not. Based on what's in the Second Amendment complaint, and more importantly, based on what's not in the Second Amendment complaint, the Second Amendment complaint against Mr. Bertolino can't stand. Turning to the law, Judge. The case law is clear that the court serves a gatekeeper function when it comes to intentional infliction of emotional distress. In the Liberty Mutual case, and Your Honor, this is in our case law binder, tab 66, but this is a case that Judge Carroll cited quite a bit in his order. It's Liberty Mutual versus Stedman. The site is 968 Southern 2nd, 592. It's a Second District Court of Appeals case from 2007. This talks about whether or not a complaint can state a cause of action for intentional infliction of emotional distress. And this case, as every other that interprets it, identifies that threshold as a question of law for the court. So oftentimes we find ourselves at motions to dismiss where the court asks me, Mr. Meltz, isn't that more of a summary judgment argument? Isn't it factual? Whether or not a complaint sets forth a cause of action for intentional infliction of emotional distress is a question of law. So it's clear from the case law that Your Honor, at this somewhat early phase in the litigation, has the legal authority and the legal requirement to make that determination. It's not for a jury to make at a later day. And it's also something that no deposition or discovery is going to affect because, again, we have to look at the four corners of the complaint and determine, does it meet this standard? And as the court in the Liberty Mutual versus Stedman case discussed, behavior claimed to constitute the intentional infliction of emotional distress must be so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency. That's the standard. So we have to take that standard and we have to look at what's alleged in the Second Amendment complaint and see if it meets that standard. In applying that standard, the subjective response of the person who is the target of the actor's conduct does not control the question of whether the tort of intentional infliction of emotional distress occurred. Rather, the court must evaluate the conduct as objectively as is possible to determine whether it is, quote, atrocious and utterly intolerable in a civilized community, whether conduct is outrageous enough to support a claim of intentional infliction of emotional distress is a question of law, not a question of fact. So, Your Honor, you have the task and the burden of reviewing the language and the paragraphs that we just read through and determine whether Mr. Bertolino offering hope on September 14th and offering prayers on September 19th on behalf of his clients, as their attorney, as their agent, in a general sense, non-targeted, with no reason, motive, or any other factor to make these mean-spirited in any way, but you have to determine whether those allegations rise to that level of utterly intolerable in a civilized community. And again, Judge, hopes and prayers can't rise to that level. And the allegations that there was a duty somehow not to be silent, but to disclose, that there was a duty to make the plaintiffs aware of whether or not Ms. Petito was alive, and if she wasn't, where her body was. That's just not a duty that exists under the law, and it's not a cause of action that exists under the law. And again, Judge Carroll incorporated that in his last ruling, and there's no case law to suggest anything to the contrary. We've cited other cases, Judge. They all say the same thing. It's a tremendous burden to show truly horrific conduct. That burden has not remotely been met here, yet alone tied into legally causing actual severe emotional distress or damages. Separate and apart from that, Judge, and I'm winding down, despite the fact that it's not properly alleged and can never be, and despite the fact that the law creates a burden that the plaintiffs can't hurdle, we also point out, as set forth in the restatement and various other cases, that separate and apart from those issues, even if the court were to find that this conduct was utterly atrocious, an attorney who was functioning as Mr. Bertolino did, who is representing the Laundries, who themselves are unwittingly and unasked for part of a horrific situation in which all of the events are ongoing as they were, it is legally permissible for Mr. Bertolino, as the Laundrie's attorney, to make statements like the ones that he did. And the restatement of torts is clear that when an actor acts in a legally permissible way, there cannot be intentional infliction of emotional distress. They give examples of a landlord who knows a family sick, but they didn't pay their rent, so they're evicted. The landlord clearly knows that putting them out on the street would cause intentional infliction of emotional distress, but they were legally entitled to do so. In the various insurance company cases where the insurance company would ask about whether someone qualified for Medicare or whether they met certain conditions, even though there may have been a denial or delay in treatment, they couldn't be held responsible because they were legally permitted to do so. To suggest that Mr. Bertolino, as the Laundrie's attorney, wasn't legally permitted to make a statement to the general public of a hope and a prayer in an extraordinarily difficult circumstance would suggest that any lawyer acting in that type of circumstance would be at risk for unintentionally causing emotional distress or unintentionally offending someone or unintentionally causing someone ill feelings or grief. There's no way to navigate that situation. You have two families who are going through something no one can prepare for, something that no one should prepare for or ever expect. But both families have their own issues, and the Laundries needed Mr. Bertolino. Mr. Bertolino acted as their attorney, and as the Second Amendment complaint says, at all times he was acting as their agent, and as such he was legally permitted to make the statements that he made, which themselves are not actionable. Finally, Judge, I do note that Judge Carroll addressed the statements at issue, not really the September 19th statement, but the September 14th statement, where he talked about context. I would note, though, that Judge Carroll did not talk about context with Mr. Bertolino as a party, as a defendant. And also, Judge Carroll's discussion about context didn't factor in all of the other elements, such as causation, such as intent, such as recklessness. He simply addressed what was pled and filled in the context. With that said, though, Judge, the full statement creates a much bigger context, which Judge Carroll did not have the benefit of last time, and which I think contextually makes the statement much more understandable and benign. And then secondly, while Judge Carroll discussed the Stedman Liberty Mutual case, He didn't talk about that part where it said, in applying the standard, the subjective response of the person who is the target of the actor's conduct does not control the question. Nor did he address that the plaintiffs weren't the target, because again, the statement itself was publicly disseminated. It's an emotional case. The issues are complex. There's no bright line rule. It's very doubtful we'll ever see this exact fact pattern again. But none of that changes that the Second Amendment complaint still has to set forth a recognizable cause of action, and it doesn't. And it's just white or black, Judge. And so with that said, the court needs to dismiss it. At a minimum, if the court doesn't dismiss it, then clearly those parts that need to be dismissed need to be dismissed. Those parts being the failure to disclose, the failure to act, the failure to speak, none of which is supported by law. So our position would be the entire Second Amendment complaint, or rather the counts against Mr. Bertolino, but I'm sure Mr. Luca will have a similar argument. But the Second Amendment complaint against Mr. Bertolino needs to be dismissed in its entirety. If not, it certainly needs to be pared down. And as to prejudice, Judge, I would note that we are on the Second Amendment complaint. There's been 2 prior amendments. This is the 3rd opportunity to set forth a cause of action. The framework to the count was clearly argued last time. Judge Carroll's order was instructive. The case law has been at issue. Presumably, if there were better allegations that could be met against Mr. Bertolino, they would be in the Second Amendment complaint, and they're not. So based upon that, our position is the Second Amendment complaint against Mr. Bertolino should be dismissed, and given the procedural history in the case, should be dismissed with prejudice. Thank you.
All right, thank you so much, sir. Thank God. Mr. Riley, do you want to let Mr. Blue go when you respond to both of them, or did you want to go now and then?
Since their arguments are basically the same, I'm fine with Mr. Luca going now.
Okay.
Thank you, Your Honor. May it please the court?
Absolutely.
Your Honor, I will try not to replow the same ground as Mr. Meltz, but I'm sure I will. Okay. So I just want to apologize in advance. So, Your Honor, in the plaintiff's response to our motion, they assert that we are simply trying to overrule Judge Carroll's order. Now, while we are asking the court to dismiss the action, which Judge Carroll did not do, our arguments in this motion are, for the most part, issues Judge Carroll did not consider. Most specifically, as Mr. Meltz pointed out, his client wasn't a defendant at that time. But there are other issues for my clients as well. At the first motion to dismiss hearing, the plaintiff's theory, at least as we interpreted it, was that the Laundries caused them emotional distress by failing to communicate about Brian and Gabby, specifically to disclose Gabby's whereabouts. And that theme is repeated again in the Second Amendment complaint and also in their response to our motion to dismiss. So our primary focus at that first hearing was that the Laundries had a number of constitutional and other legal rights that protected their communications and activities, and thus they had no duty or obligation to act in a certain way or to communicate information. Now, Judge Carroll did agree that the bulk of the plaintiff's allegations did not support the cause of action because the defendants had no duty to speak under the circumstances. Now, I don't know if the court wants me to re-argue those points or if you would prefer that I just pick up from where Judge Carroll's findings.
I've read Judge Carroll's findings in the past, and I've briefed them again this morning. So if you want to go over that, you can, but it's your case to argue. So.
Absolutely. Thank you, Your Honor. And if you do have any questions about what we argued at that point, how Judge Carroll came to that, I'm happy to answer.
I would be happy to ask.
So at the first hearing on the motion to dismiss, Mr. Bertolino's statement at that time was really just one of many allegations, and admittedly, we didn't focus on it in our argument, probably as much as we should have. However, Judge Carroll found that of all the allegations, because Mr. Bertolino's statement was an affirmative act, which, although in isolation did not rise to the level of outrageous conduct, that it's possible the plaintiffs could develop some context for it that could render it outrageous. Like I said, we didn't concentrate as much attention on the statement as the first hearing as we should have. And knowing now that it was the critical allegation in the case, we should have focused our arguments on that topic, so that's what I'll do now. In that regard, we're not asking the court to overrule Judge Carroll because Judge Carroll did not have the benefits of a lot of the arguments we're going to assert today. First, Judge Carroll did not have the benefit of Mr. Bertolino's entire statement. Plaintiffs only included the one paragraph out of the three paragraphs in the original complaint and also in the Second Amendment complaint. And as Mr. Meltz said, by stipulation, the court can consider all of those paragraphs for purposes of this hearing. Second, Mr. Bertolino's statements were legally protected both by the privilege afforded to the exercise of permissible conduct when it comes to a cause of action for intentional infliction of emotional distress, and also the litigation privilege. Third, whether the statement alone, as opposed to the other allegations that Judge Carroll found did not support the cause of action, was either produced or substantially contributed to producing the severe emotional distress. Fourth, whether Mr. Bertolino's public statement, again, as opposed to the other allegations, satisfies the requirement that it be directed at the plaintiffs and in their presence. And lastly, the addition of the allegations against Mr. Bertolino renders the allegations against the Laundries implausible. So first, Your Honor, Mr. Bertolino's statement is not outrageous. And Mr. Meltz read the statement. I won't read it, but I will talk about it. Whether the conduct is outrageous is a matter of law for the court to decide. And the plaintiff's subjective reaction to the conduct does not control. The statement itself must be objectively outrageous. Generally, an outrageous act is one in which the recitation of the facts to an average member of the community would arouse his resentment against the actor and lead him to exclaim, outrageous. If I recited Mr. Bertolino's statement to the average member of the community, their reaction would not be to exclaim, outrageous. They would probably think it sounds like a statement they have heard many times before by an attorney in a public comment about a case. Basically, a statement that says nothing of substance and is an attorney just trying to say something favorable for one of his clients. In paragraph 39, which is on page 19 of the plaintiff's response to our motion, they acknowledge that the statements, and when I say statements, I mean the September 14th statement and the September 19th statement, without context, seem to be an appropriate expression of sympathy and understanding for the trauma which the Petito family was undergoing. Had they been said by anyone else but the Laundries or Bertolino, they would be interpreted as genuine and sincere. So basically what the plaintiffs are saying is the statements are not outrageous, but the plaintiffs did not interpret them as genuine and sincere, and thus it caused them distress. So going back to the standard, Your Honor, objectively, the statement is not outrageous, but subjectively, the plaintiffs interpreted it as such. That's not the standard for liability. The subjective interpretation of the plaintiffs does not control. It is an objective standard, and by objective measure, the plaintiffs even acknowledge that the statements are not outrageous.
Is it objective just taking the statement as it is without any context, or is it the objective person sitting in the same exact contextual position as the plaintiffs?
That's an interesting question, Your Honor, because the way that the case law frames it is an outrageous act is one in which the recitation of the facts to an average member of the community. So I would submit that the standard takes into account what an average person would think within the community, not necessarily the plaintiff in that position considering whatever the conduct is that's alleged to be outrageous. Now, I don't have a specific case that discusses exactly how the court would consider that issue.
Question, because that's what I said. You said that, but has any court said that?
Your Honor, other than the quote that the outrageous act is one in which the recitation of a facts to an average member of the community, that is a citation.
Okay. You probably already said it, but just in case
hang on, let me pull that up, Your Honor. And I'm guessing just off the top of my head that it's probably the Metropolitan case, but I will double check that. So it's Eastern Airlines Incorporated versus King, and the site for that is 557 Southern 2nd, 574, page specifically 576, and that's a Florida Supreme Court case from 1990.
Okay, thank you.
And Your Honor, I would also, in addition, again, citing the Metropolitan Life Insurance Company versus McCarson, the site for that is 467 Southern 2nd, 277, and that's again a Florida Supreme Court case, and it's from 1985.
467.
467 Southern 2nd, 277.
Okay, perfect.
Specifically, page 278. And again, that's the case that essentially adopted the cause of action for intentional infliction of emotional distress in Florida. And in that case, Your Honor, again, one of the standards that the court has to consider is the court must evaluate the conduct as objectively as possible to determine whether it is atrocious and utterly intolerable in a civilized community. Again, Your Honor, sort of referencing that the standard involves what a person within the community would think of it, not necessarily how a specific person in the specific position of the specific plaintiff might consider that particular conduct. But Your Honor, if you'd like, I can do some research after the hearing and just submit a supplemental to the motion to try to pinpoint that issue.
I can probably do it myself. That's the question that it appears to me that Judge Carroll has already answered that question from a motion to dismiss standpoint, though. That's where I'm having some trouble with your argument. And I understand that you're saying, well, now we have the full statement. But you're saying that the full statement changes the context in which the middle part should be read.
Yes, Your Honor, that is my position.
All right.
Because I'll get to that, but essentially my position is that taking that middle paragraph in isolation without the two paragraphs that both precede and follow it, because those two, the first and the third paragraph really do provide the context for why the plaintiffs wouldn't necessarily regard that statement as what they claim it to be. In other words, the explanation that Mr. Bertolino offers sort of puts it in the position of, hey, we know this statement might not be enough, but based on the advice of our attorney, it's all we can say. That's what the last paragraph of the statement says, which is important for our purposes because really what the plaintiffs are saying is you should have said more. And that's really what Judge Carroll said too, is there could be context where perhaps they should have said more in the statement, or the statement should have been worded differently, whatever it might be. Considering the context of that last paragraph, it's informing the plaintiffs, I'm sorry that this statement may not be to your liking, but based on the advice of our attorney, this is all that can be said. So that's our position. And Judge Carroll didn't consider that position at all because the full statement was not in the record at that time. We didn't argue those other paragraphs at all. And Your Honor, we believe that this is a fundamental flaw in the plaintiff's cause of action, is that it is based on their subjective interpretations and general cynicism for anything the Laundries did. For example, they claim that the Laundries' visit to Fort DeSoto Park was outrageous. And they claim that Mr. Bertolino's September 19th statement, in which he offers condolence and prayers for Ms. Petito's death, that's outrageous. That's a subjective assessment. I mean, I don't know that there's any reasonable person that would objectively think somebody going to a park would be outrageous. Your Honor, I really think that, I know the plaintiffs allege a lot within their complaint, maybe not as much as they should to meet this cause of action, but the statement by the plaintiff's attorney that's alleged in paragraph 35 of the Second Amended Complaint and plaintiff's response to the motion, really when it's boiled down to the essence, what they really complain about is that the Laundries did not disclose Gabby's whereabouts. That seems to be the information that they really, that's really at the heart of their complaint. But what's interesting about the complaint is that they don't actually allege that the Laundries ever knew Gabby's whereabouts. As Mr. Melt said, it's insufficient for them to plead opinions, theories, legal conclusions, or argument. The court does not have to accept those as true for purposes of deciding the motion to dismiss. The only allegation of any substance that the Laundries knew anything is at paragraph 20 of the Second Amended Complaint. And there it says, "It is believed and therefore averred that on or about August 28th, 2021, Brian Laundrie advised his parents, Christopher and Roberta Laundrie, that he had murdered Gabrielle Petito." They do not ever allege that Brian told his parents Gabby's location or any other details. And other than that one allegation, they don't allege any other conversations with Brian. They don't allege any conversations with Mr. Bertolino or some other source where they may have learned that information. They don't allege how, if the Laundries had that information, how they would have come to know. For that reason, Your Honor, with respect to that issue, there are no allegations in the complaint other than conclusions or theories that the Laundries knew Gabby's whereabouts. And so if the plaintiffs don't even allege that the Laundries knew that fact, their cause of action can't be based on a failure to disclose it. Now, plaintiffs may try to argue that the Laundries' knowledge can be inferred from their other allegations. Your Honor, I would submit that that's not a reasonable inference. Again, first of all, they don't allege any other conversations with Brian Laundrie other than that one conversation. Second, as we know now, and as alleged in the complaint, Ms. Petito was found in a remote part of a national park in Wyoming. It's not a reasonable inference to assume that the Laundries would have known that location, or that they could have even found out where that was. Your Honor, intent is also a critical factor here, and one in which the plaintiffs offer no concrete allegations other than conclusions. I'll discuss intent again when addressing the plausibility of the allegations against the Laundries, but juxtaposing the intent required in order to commit this tort with the words of Mr. Bertolino's statement and the other allegations of the complaint, there simply isn't outrageous conduct. The standard is, with regard to intent, that it's not enough that the defendant act with an intent which is even tortious or criminal, or that the defendant intended to inflict emotional distress, or even that the defendant's conduct can be characterized by malice or a degree of aggravation which would entitle the plaintiff to punitive damages for another tort. And again, Your Honor, this is the Eastern Airlines case that I cited earlier. Rather, liability is established only where the alleged conduct is so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency and to be regarded as atrocious and utterly intolerable in a civilized community. Now, Your Honor, I did touch on our argument with regard to the paragraphs earlier, but I'll go through it in a little bit more detail here. So the first paragraph of Mr. Bertolino's statement acknowledges the difficulty of the situation for both families, which is important. It acknowledges what the plaintiffs were going through, and the struggle that the Laundries were also balancing. Certainly a situation that neither family expected to be in, and one that was full of challenges for everyone involved. Now you couple that with the third paragraph, which basically says, I'm sorry, I know you would like us to say more, but we cannot on the advice of our attorney. We are going to stay in the background. The statement conveys, we understand how hard this is for you, but our son is in trouble, and we have to rely on the advice of our attorney in this extremely difficult circumstance. Far from being outrageous, that is exactly what most people in that situation would be thinking and doing. Those two paragraphs are critical because they run contrary to the plaintiff's conclusory allegations that the Laundries acted with malice and ill will. To the extent the Laundries withheld information with some sinister intent, which I'm not saying they did, that is facially disproved by Mr. Bertolino's statement that the Laundries will not provide additional comment based on the advice of counsel. Now the plaintiffs want to focus on the middle paragraph, which is probably why they omitted the other two paragraphs from the complaint. Now the first sentence of the middle paragraph says that a search was organized in Wyoming. A factually accurate statement. I don't think anybody is disputing that. The second sentence, which says, we hope the search is successful and Miss Petito is reunited with her family. Now the plaintiffs claim that that sentence caused them distress because it made it seem as though Miss Petito could still be alive. Now, on its face, the statement does not indicate that Miss Petito was or was not alive. It is an ambiguous general expression of hope. And we've cited a number of sources in our brief where the term reunited is used to describe when a deceased person's remains are returned to family members. That's a term used by the National Institutes of Health, the Reuniting Families Project, the United States Army, and a number of news organizations. Now, the plaintiffs dismiss this fact, but again, the plaintiff's subjective interpretation of the statement is not what controls. It's the objective interpretation. And those sources that I cited, government agencies and other news organizations, would use that word to describe when a deceased person's remains are returned to their family.
So you're saying from an objective standpoint, a reasonable, prudent person, if they are told, we hope that Miss Petito is reunited with her family, that the reasonable, prudent person would believe that to objectively mean that her remains would be reunited?
Really, what I'm
in all instances.
I'm not saying. Yeah, I'm not saying in all instances, in all contexts, Your Honor. Really, what I'm saying is that the statement is ambiguous. And so somebody reading that statement would not necessarily immediately jump to the conclusion she must be alive.
Okay.
And, Your Honor, with respect to the plaintiff's assertion that they interpreted Mr. Bertolino's statement to give false hope that Miss Petito was alive, it's contradicted by the allegations of the second amended complaint. So Mr. Bertolino made his statement on September 14th, 2021. And then 2 days later, the attorney for the Petito family, Richard Safford from New York, issued a statement to the Laundries, and it's found at paragraph 35 of the second amended complaint. And I won't read the whole statement, but specifically within that statement, Mr. Safford says, we believe you know the location of where Bryan left Gabby. And then later the statement says, how can you keep her location hidden? Please, if you have any decency left, please tell us where Gabby is located. Now, the attorney asked 3 times in that statement about Miss Petito's location, but not once did he ask for clarification about whether or not Miss Petito was alive. Clearly, at the time, the plaintiffs and their attorney did not believe that Mr. Bertolino's statement meant that Miss Petito was still alive. I think it's also important to note that this statement by the plaintiff's attorney focuses on Miss Petito's location as the information that the plaintiff sought. But as mentioned previously, there are no actual allegations, as opposed to opinions or conclusions, that the Laundries knew anything about Miss Petito's location that they could disclose. again, paragraph 20 only alleges that Bryan informed his parents that he had murdered Miss Petito, not the location. And in that same statement, Your Honor, by the plaintiff's attorney, he acknowledges the complicated situation faced by the Laundries. He says, "We understand you are going through a difficult time, and your instinct to protect your son is strong." Again, Your Honor, conveying that they understood why the plaintiffs maybe couldn't say more. They recognized the situation, the difficult situation that everybody faced. So again, that statement suggested they were not insulted by their statement. They were not caused distress necessarily by the statement. They understood why the statement said what it did and why it didn't say other certain things. Your Honor, if we compared the plaintiff's attorney's statement with Mr. Bertolino's statement, I don't think that we would say that the plaintiff's attorney's statement was tortious. The plaintiff's attorney expresses understanding for the Laundries' unenviable position, just like Mr. Bertolino did, and then, questions whether the Laundries had any decency left and things like that. And arguably, Your Honor, this statement was a violation of the rules of professional conduct because it was an attorney directly contacting a party who he knows to be represented by another attorney as opposed to going through that person's attorney. But regardless, Your Honor, the point is we could parse every public statement that an attorney makes and raise a cause of action for intentional infliction of emotional distress if that's what we're going to do in this case. This statement is not outrageous by Mr. Safford, and neither is Mr. Bertolino's statement. They're just public statements by attorneys during a very, very difficult situation for both families. Now, ultimately, the court has to decide whether Mr. Bertolino's statements were atrocious and utterly intolerable in a civilized community. And I would argue, Your Honor, if in a statement by an attorney that's expressing sympathy, hope, condolence, trying to explain the difficult situation of his clients is utterly intolerable in a civilized community, then I believe we've lost our way as a society. Now, I know that the plaintiffs allege another statement by Mr. Bertolino, Your Honor, in which he says the news about Gabby is heartbreaking. The Laundrie family prays for Gabby and her family. Your Honor, I don't think there's any context in which that statement could ever be outrageous. And regardless of whether the statement was outrageous, the complaint does not allege that Mr. Bertolino made that statement on behalf of the Laundries, as he did the September 14th statement. So it shouldn't be considered against them in any way. Now, Mr. Meltz touched on two cases that were probably the foundation of Judge Carroll's order. The first, Williams versus City of Mineola, and the site is that is 575 Southern 2nd, 683, and that's a 5th DCA case from 1991. Again, it's 575 Southern 2nd, 683. Your Honor, in that case, a 14-year-old died of an apparent drug overdose, but there was also an investigation as to whether or not foul play may have been involved. And the Orlando Sentinel published an article describing a party at one of the police officers' homes where they viewed the video and pictures of the autopsy of this young boy, where the audience were joking and laughing, mocking the pictures and whatnot. And now, the plaintiffs cite this case for the proposition that a grieving family is particularly vulnerable. And I would agree with that. That's what the case and the restatement, they do allow for that. But I believe the holding of Williams is a little more specific than that. Specifically, Williams said that a grieving family is especially sensitized to any disrespect or indignity directed at the decedent's body or representation of it. The potential for severe emotional distress is enormously increased in that situation. Your Honor, in this case, Mr. Bertolino's statement did not direct any insulting or disrespectful comments against Ms. Petito, so it is distinguishable from Mineola, City of Mineola in that regard. Your Honor, I would also comment F of Section 46 of the Restatement of Torts, which is the section regarding vulnerable family members. It states, the extreme and outrageous character of the conduct may arise from the actor's knowledge that the other is peculiarly susceptible to emotional distress by reason of some physical or mental condition or peculiarity. The conduct may become heartless, flagrant, and outrageous when the actor proceeds in the face of such knowledge, where it would not be so if he did not know. And now, this is an important part, Your Honor. It must be emphasized again, however, that major outrage is essential to the tort, and the mere fact that the actor knows that the other will regard the conduct as insulting or will have his feelings hurt is not enough. Now, the City of Mineola case, while it supports the notion that grieving families are vulnerable, it does not say that any statement by an attorney for a suspect in a criminal case is per se outrageous just because the attorney for the accused said it. There must be major outrage. It is also important to note that the behavior in this case, the Mineola case, was by the police officers investigating the death. Now, those police officers held a unique position as to the victim's family, as the victim's family would be relying upon them to fulfill their investigative duties in a professional way. Your Honor, the other case, the Liberty Mutual Insurance Company versus Stedman case, which was cited in Judge Carroll's order. It was the primary case he relied upon for his determination that context was important. In that case, Your Honor, the insurance company delayed paying for a double lung transplant for one of its insureds. A judge of compensation claims ordered the insurance company to pay for it. Despite that order, the insurance company ignored it and continued to delay with the intention that the plaintiff would die, and so they wouldn't have to pay for the lung transplant. Now, again, Judge Carroll cited this case for the proposition that context is important. First of all, Your Honor, one important distinction is the insurance company had a duty to pay for this surgery. Not only a contractual duty by the terms of their insurance policy, but they were also ordered by a judge to pay for it. And they ignored that duty in delaying paying for the surgery. Now, Your Honor, I do disagree with Judge Carroll in this regard. The basis for his statement, the basis for his holding was that Mr. Bertolino's statement was, by all accounts, benign and not outrageous. But if the defendants knew something or there was other context for the statement, then the statement could be outrageous. Your Honor, I would argue that if that were the case, that would impose a duty on the defendants to, if they spoke at all, to disclose something more than what they did. And that's not a duty that they had. For example, if, a reporter asked Mr. Riley and I a question, and we withheld some information in response to the question, we're not legally obligated to provide a complete and total answer with all the information that we know about that subject. That's certainly not a duty the law would impose on us. And in fact, Your Honor, in that circumstance, we would probably run afoul of the attorney-client privilege if we disclosed everything we knew about it.
Or could Judge Carroll's order rather mean that with the facts ultimately coming to light through discovery and otherwise, that this issue may be one that is better suited, this question may be one that's better suited for summary judgment or trial?
I think you're right, Your Honor. I mean, I do think that that's what he was getting at was, I'm going to give the plaintiffs an opportunity to see if they can develop some additional facts, and then I'll reconsider this issue at summary judgment.
I mean, but we're still at motion to dismiss, so we're still kind of at the same spot that he was at.
Yes, Your Honor, we are still very much at that same spot.
Okay.
Although, again, as I said, Your Honor, my feeling is that even if the plaintiffs had some other information that they didn't disclose in that statement, and that's uncovered in discovery, that doesn't mean that they had a duty to disclose it. They aren't required to disclose everything they know every time they speak. that even in this context, Your Honor, Mr. Bertolino's statement was very clear that they were not going to say more based upon the advice of counsel. That's important context for it. That conveys that you may not like what we said here. It may not be enough. It may not be exactly what you would want us to say, but we have a right to rely on the advice of our attorney and not say more. Okay. That I think is an important distinction, Your Honor. Your Honor, another issue related with the Stedman case. I know the plaintiff cited on the issue of unequal positions, which again is another subparagraph of Section 46 of the restatement. But Your Honor, my position is that that's really a red herring. So what the unequal position section of the restatement said, it's subsection E of 46. The extreme and outrageous character of the conduct may arise from an abuse by the actor of a position or a relation with the other, which gives him actual or apparent authority over the other or power to affect his interests. Thus, an attempt to extort money by a threat of arrest may make the actor liable, even where the arrest or the threat alone would not do so. In particular, police officers, school authorities, landlords, and collecting creditors have been held liable for extreme abuse of their position. Even in such cases, however, the actor has not been held liable for mere insults, indignities, or annoyances that are not extreme or outrageous. The extreme and outrageous nature of the conduct may arise not so much from what is done as from abuse by the defendant of some relation or position which gives the defendant actual or apparent power to damage the plaintiff's interests. The result is something very like extortion. Successful actions have been prosecuted in this context based on outrageously high pressure tactics of collection agencies, other creditors, and insurance adjusters seeking to force an unfair settlement. And Your Honor, that's cited from Dependable Life Insurance Company versus Harris. That's 510 Southern 2nd, 985, specifically page 988, and that's the 5th DCA case from 1987. So, Your Honor, somebody involved in a criminal investigation making a public comment is not really what's intended by this subsection. The conduct must be something like extortion, where the person abuses their authority to extract something from the other person, and that's really not what we have here. Your Honor, I mentioned intent earlier, and the plaintiffs have alleged that the Laundries maliciously and willfully inflicted emotional distress. Now, in both of these cases that I just discussed, the intent is fairly clear. In Williams, police officers who were supposed to be investigating the victim's case openly mocked and joked about his death during a party. By all objective measures, very unprofessional, and done with the intent to mock the deceased, to make fun of him. And, Your Honor, just like Judge Carroll mentioned, duty is important in this context. And you could say that police officers have a duty, or at least an expectation, to be professional with victims and their families. Now, in the Stedman case, the insurance company clearly acted with the intent to disregard the judicial order and with the hope that the plaintiff would die. The insurance company clearly acted with ill intent. Now, nothing about Mr. Bertolino's state comes close to that level of callousness. Nor did he have a duty to say more than he did. And other than general recitations of intent, the complaint has no specific factual allegation demonstrating that the Laundries or Mr. Bertolino harbored an intent to act outrageously or to do harm, which they're required to have. Rather, Your Honor, again, if you look at that first paragraph of his statement and the last paragraph of his statement, the first paragraph being that we're really sorry about this, but it's difficult for both families. We know you're going through something difficult, but we are too. And then the last paragraph where he says, I'm sorry, we can't say more based on my advice as an attorney. Now, the plaintiffs acknowledge that their cause of action on these facts is novel. And it is novel because Mr. Bertolino's statement is not outrageous. Everyone involved in this tragic saga had rights that protected them. And those rights may have worked to the detriment of others. But the exercise of those rights is not objectively outrageous. We can all imagine where the exercise of rights may be subjectively outrageous to the person who is disadvantaged by the exercise. But objectively, the law must protect the exercise of rights. Now, this leads me to my next argument, Your Honor, which is that Mr. Bertolino's statement was legally protected. There's two ways in which it was protected. The first, the privilege to do what is legally permissible, and second, the litigation privilege. So from the first recognition of the tort of intentional infliction of emotional distress, the Florida Supreme Court has emphasized that the conduct, although it would otherwise be extreme and outrageous, may be privileged under the circumstances. The actor is never liable, for example, where he has done no more than insist upon his legal rights in a permissible way, even though he is well aware that such insistence is certain to cause emotional distress. And, Your Honor, that's the Metropolitan Life Insurance Company case, which I cited earlier. It's 467, Southern 2nd, 277, Florida Supreme Court, 1985. And this principle has been upheld many times since, and we cite to some of those cases in our brief. Now, as an initial matter, our first motion to dismiss discussed a number of rights that protected the Laundries from having to say anything. And as Mr. Bertolino put it in his statement, they could remain in the background. That was their legal right. And Judge Carroll summed up that finding that the Laundries had no duty to do anything, even if the plaintiffs wanted them to do more. As I discussed, I disagree with Judge Carroll with the regard as to whether or not that duty should be extended to whether they needed to say more in the statement, in Mr. Bertolino's statement. I would argue that the law doesn't impose a duty on them to say more than what they did. Now, as it relates to Mr. Bertolino's statement more specifically, there is an additional way in which he was exercising his professional obligation in a permissible way. ABA Model Rule of Professional Conduct 3.6 permits an attorney to make a statement to protect his client from adverse publicity. Specifically, that rule says, notwithstanding paragraph A lawyer may make a statement that a reasonable lawyer would believe is required to protect a client from the substantial, undue, prejudicial effect of recent publicity not initiated by the lawyer or the lawyer's client. A statement made pursuant to this paragraph shall be limited to such information as is necessary to mitigate the recent adverse publicity. And again, that's ABA Model Rule of Professional Conduct 3.6, subsection C. Now, plaintiffs argue in their response that there are not enough facts within the second amended complaint to infer that Mr. Bertolino's statement was made under these circumstances covered by the rule. Your Honor, I would disagree. So, first of all, the plaintiffs allege that Brian Laundrie murdered Gabby Petito. That's at paragraph 16. They reference the search in Wyoming, paragraph 28. They allege that the Laundries and Mr. Bertolino were assisting Bryan to flee the country. Again, we vehemently oppose that, but they allege it. They specifically set forth at least 3 public statements by attorneys that were published to the media for both families. It's paragraph 31, 35, and 38. They allege Mr. Bertolino's September 14th statement was intended to be disseminated nationwide and was broadcast in news reports in Florida and nationwide. Again, paragraph 31. They also allege that Mr. Bertolino released, I'm quoting, numerous other statements regarding Christopher Laundrie, Roberta Laundrie, and Brian Laundrie to the national press, paragraph 33. And they allege that Mr. Bertolino gave a televised interview in October of that year, paragraph 27. There are enough allegations to support that there was media attention on the case. Now, the rule itself does not require a certain level of publicity that the attorney is responding to. It just says recent publicity. It could be a response to one article about the case, but certainly the plaintiffs have alleged enough in here, enough in their second amended complaint to support that there was publicity on the case that Mr. Bertolino could be responding to. Regardless of whether the facts of the second amended complaint fit neatly into the model rule, the standard is whether Mr. Bertolino and the Laundries were insisting on their legal rights in a permissible way. Even if every element of Model Rule 3.6c is not satisfied by the allegations of the complaint, the mere existence of the rule demonstrates that Mr. Bertolino had a good faith basis and legal right to make the statement. Now, plaintiffs argue in their response that if Mr. Bertolino was issuing a statement to protect his clients, he would have given what the plaintiffs wanted, which was Gabby's location. First, the rule does not specify what kind of statement an attorney must make. Second, such an argument would impose a duty on the defendants to, if they spoke at all, to disclose everything, which again, we don't believe the law imposes that duty. And then third, Your Honor, the statement Mr. Bertolino gave, while not satisfying to everyone, was the best he could do under the circumstances. It acknowledged the plaintiff's grief, while also informing them that the Laundries could not say more based upon the advice of counsel. Now, Your Honor, I'll turn to the litigation privilege.
Before you do that, with the ABA model rule, what would provide that as being legally permissible?
Well, Your Honor,
he's not a member of the. He's a member of the New York Bar. Right?
Exactly, Your Honor. Yes.
So, and he was making allegedly those statements in Florida. So, are those model rules are intended to be adopted by bar associations? So I mean, I don't know that we have one in a Florida bar that.
Your Honor, you're right. I don't know that we do. Although I would say I don't believe Mr. Bertolino made the statement in Florida. I believe he may have made it in New York or someplace else. Obviously,
he's not governed by the Florida bar.
Exactly, Your Honor. He is not.
So, I mean, I guess that's the ABA model rule. Those are just what they say. Model rules. We have model rules and laws nationwide. That doesn't mean that they're actually laws we have to follow.
No, you're right, Your Honor. And it's not so much that it's a law that he would be required to follow. But what it is a recognition that an attorney can make a statement like this, a public statement like this, and not run afoul of rules of professional conduct. It is a permissible rule, not so much a rule that seeks to.
But it's not a permissible rule in the state of Florida.
I agree with you, Your Honor. Yes, it's not a permissible rule in the state of Florida. Okay. Yes. I would agree with that point.
I just wanted to make sure that there wasn't something similar in New York or that you were going off of that.
I don't know about New York, Your Honor. I do know that in Florida, I don't believe that rule is part of our rules of professional conduct.
Next time you go to a bar convention.
I'll bring it up, Your Honor. Excuse me, I'm just going to grab a sip of water
while
we're taking a short break here. So, Your Honor, turning to the litigation privilege. Now, the litigation privilege is based on a recognition of the necessity that certain persons, namely attorneys in this context, because of their special position or status, should be as free as possible from fear that actions in that position might have an adverse effect upon their own personal interests, which is really what we have here. To accomplish this, it is necessary for them to be protected not only from civil liability, but also from danger of even an unsuccessful action. Now, Your Honor, while that's important to my clients, is that if a principal's liability rests solely on the doctrine of respondeat superior, a principal cannot be held liable if the agent is exonerated. So if Mr. Bertolino can invoke the litigation privilege, then my clients cannot be legally responsible for whatever conduct he did that caused the invocation of that privilege. Now, Florida has recognized both absolute immunity and qualified immunity in the litigation privilege context. Now, typically, the absolute immunity is afforded to statements made in the course of judicial proceedings or trials. But it also includes proceedings before a competent court or magistrate in the due course of law or the administration of justice, which is to result in any determination or action by such court or officer. This privilege extends to the protection of the judge, parties, counsel, and witnesses and arises immediately upon the doing of any act required or permitted by law in the due course of the judicial proceedings, and then here's the important part, or as necessarily preliminary thereto. And then, Your Honor, that's Fridovich versus Fridovich. That's 598 Southern 2nd, 65, Florida Supreme Court, 1992. And that's citing another Supreme Court Ainge for that same proposition. Now, Your Honor, as we pointed out in our brief, the Florida Supreme Court has not addressed whether absolute or qualified immunity would extend to a lawyer's comments in a situation like this. As the plaintiff's cause of action is novel, so is our request to extend the litigation privilege in response to it. Now, the Florida Supreme Court has extended the absolute privilege in certain pre-litigation contexts, specifically the Ainge case that I referenced. It's Ainge versus State, 123 Southern 9. It's an old case, Southern 916, and that's from Florida, 1929. And in that case, Your Honor, the court found that the absolute privilege barred an action for defamation based on statements made in the office of a county judge to whom the defendant had gone to obtain a warrant. Your Honor, also Robertson versus Industrial Insurance Company, that's 75 Southern 2nd, 198. That's Florida Supreme Court, 1954. Absolute privilege applied to defamatory statements made in a letter to the insurance commissioner used to initiate license revocation proceedings.
Give me the last the page number for the Ainge.
Sure. So 123 Southern 916.
Thank you. Perfect.
Now, the Florida Supreme Court has also recognized a qualified privilege rather than an absolute privilege in the context of statements made to police in a criminal investigation prior to the initiation of criminal proceedings, and that was the Fridovich case that I cited to you earlier. Also in Delmonico versus Traynor, the site for that is 116 Southern 3rd, 1205, Florida Supreme Court, 2013. And in that case, Your Honor, the Supreme Court extended the qualified privilege to statements made by an attorney as they undertook an informal investigation and interviewing witnesses. And so now, Your Honor, we acknowledge that this case does not fit neatly into any of these examples, and we would be asking the court to extend the privilege to the context where an attorney makes a public statement in the face of a criminal investigation of one of his clients. But again, Your Honor, relying on Model Rule 3.6, there is a basis for doing so. If rules of professional conduct contemplate an attorney making a statement, or even compelling such a statement to fulfill a duty to defend his client, then there is no reason that such a statement should not at least be protected by a qualified privilege. We can all think of countless examples where an attorney for a defendant makes a public declaration of innocence, or a prosecutor makes a public declaration of guilt before the case is decided. And now every one of those cases should not trigger a civil action for intentional infliction of emotional distress if the case turns out differently than those proclamations. Your Honor, the basis for whether an absolute or qualified privilege, the basis of such a privilege is for lawyers is to permit a free adversarial atmosphere to flourish, which atmosphere is so essential to our system of justice. That's Sussman versus Damien, 355 Southern 2nd, 809, Florida, 3rd DCA, 1977. In fulfilling their obligations to their clients and to the court, it is essential that lawyers, subject only to control by the trial court and the bar, should be free to act on their own best judgment in prosecuting or defending a lawsuit without fear of later having to defend a civil action for something said or written during the litigation. A contrary rule might very well deter counsel from saying or writing anything controversial for fear of antagonizing someone involved in the case and thus courting a lawsuit, a result which would seriously hamper the cause of justice. And again, Your Honor, that's a quote from the Sussman case. Your Honor, it is an important point that Mr. Bertolino is an officer of the court, and subject to the court's jurisdiction and also regulation by his bar association. And if he truly did step out of line, he is subject to control by those entities. His clients and him also should not face a civil action merely because of his comments about an ongoing public investigation. Now, plaintiff's response discusses the case of Ball versus D-Lights Enterprises, Inc. The site for that case is 65 Southern 3rd, 637. It's a fourth DCA case from 2011. And Your Honor, all these cases I'm citing should be in the binders, citing and everything.
One through 95.
Yeah.
And I don't want to cut you off, but I've given both of you, like, at this point, 45 minutes for Mr. Metz and 45 minutes for close to 45 minutes for you, and I just want to make sure that
Understood, Your Honor.
give plaintiffs a similar amount of time.
I will move more quickly.
Okay.
I will move more quickly. So, Your Honor, in the Ball case, in that case, a party to a lawsuit published some disparaging remarks on their own commercial website about their opponent's business practices. Now, I can understand in that context why the litigation privilege would not cover it, because it was essentially a party to litigation disparaging a business competitor in a commercial context, entirely commercial context, and it just happened that the two entities were also engaged in litigation. This context is different, Your Honor. The statement is made by an attorney, and there is a rule of professional conduct that permits that statement. That type of statement is much more closely aligned with the litigation privilege than is the statement by a private entity on their website in a commercial business context. Turning from
at what stage are these cases that you're citing getting resolved? Are they getting resolved at a motion to dismiss stature? Or
some of them, yes, Your Honor. Although, I mean, I would submit, Your Honor.
I will look through them. And,
yes, the litigation privilege probably is something that requires more factual development in certain contexts. I mean, now there may be cases where it's very obvious from the four corners of the complaint that there was a case that was initiated. I'm sure, the court could take judicial notice of certain things, if a case had been filed, if the case related, and things like that. So that's obviously not the context we have here.
Right.
I do agree with you on that.
All right.
I do agree with you on that. Your Honor, Mr. Meltz covered causation. I'll just touch on it briefly here. So the Florida Standard Jury Instruction 410.6, which is the intentional infliction of emotional distress in jury instruction, says that extreme and outrageous conduct is a legal cause of severe emotional distress if it directly and in natural and continuous sequence produces or contributes substantially to producing such severe emotional distress so that it can reasonably be said that, but for the extreme and outrageous conduct, the severe emotional distress would not have occurred. Now, the jury instruction does allow for concurring causes, but again, even a concurring cause must contribute substantially to producing the distress. Now, I don't think the plaintiffs dispute that there were concurrent causes, that they were already suffering their distress prior to Mr. Bertolino's statement, even after Mr. Bertolino's statement, that was not necessarily due to anything that Mr. Bertolino said. But, Your Honor, really what is critical here is the word producing, or substantially producing. Because as Mr. Metz pointed out, paragraph 35 of the complaint, within the statement by the plaintiff's attorney, Richard Saffold, he said, we haven't been able to sleep or eat and our lives are falling apart. Again, not caused by Mr. Bertolino's statement, just caused by the circumstances of the disappearance of their daughter. And also the way that the plaintiffs have alleged causation in this case is interesting. They say that the defendants could prevent such additional mental suffering and anguish of Joseph Petito and Nicole Schmidt by disclosing what they knew about the well-being and the location of the remains of Gabby Petito. It's paragraph 39. Failing to prevent mental suffering that is already occurring is not the same as producing it. The distress has already been produced. It's ongoing. And really what the plaintiffs are arguing is that the Laundries failed to stop it. Again, I think it's also important to point out that they allege the Laundries caused their emotional distress by not disclosing what they knew about the well-being and location of the remains of Gabby. And as Judge Carroll found, disclosure is not a duty they had. And it was also, Gabby's location is not a fact that the Second Amendment complaint alleges the Laundries knew specifically. But what we are dealing with specifically here, Your Honor, is whether Mr. Bertolino's statement produced their distress. But they don't allege that the statement produced distress. They alleged that what was not in the statement caused them to suffer continued distress, which again is not the same as producing. Your Honor, Mr. Meltz also touched on this, so I won't spend too much time on it, but for conduct to be actionable as an intentional infliction of emotional distress, the conduct must be directed at the plaintiff and in his or her presence. And that's Dunkel versus Hedman. Case is 2016, Westlaw 487-0502. And it's a Middle District of Florida federal case from 2016. We cite a number of other cases, Your Honor. I'm not going to do that now. They're in the brief for that same proposition. Now, in their response, Your Honor, the plaintiffs, in arguing against the application of the litigation privilege, which is at page 24, paragraph 55 of their response, they acknowledge this fact. They say, furthermore, the statements made by Mr. Bertolino were not made to anyone involved in any potential court proceeding. So the plaintiffs are correct. Mr. Bertolino's statements were not directed at the plaintiffs or anybody in any potential court proceeding. And as a result, they don't have a cause of action for intentional infliction of emotional distress. Now, Your Honor, my final argument, my plausibility argument, as I mentioned earlier, it's not sufficient for the plaintiffs to plead opinions, theories, legal conclusions, or argument, and the court does not have to accept those as true. Now, the two cases that set the minimum of standards for federal pleading, which Florida courts have expressed acceptance for, are Bell Atlantic versus Twombly and Ashcroft versus Iqbal. Now, Your Honor, I would submit that this complaint is full of opinions, theories, legal conclusions, and argument. As mentioned earlier, there was only one allegation of a conversation between Bryan and his parents in the whole entire complaint. And even that allegation begins with the phrase, "it is believed." There are no allegations that the Laundries learned any other information than that one allegation. Now, I want to focus on the allegations regarding the state of mind. And now, specifically, they allege that Mr. Bertolino's statement was outrageous and that all of the defendants, all three of the defendants, acted willfully and with malice in issuing it. Now, plausibility means that once the complaint has been whittled down to its non-conclusory allegations, the court undertakes the second step of determining whether the complaint states a plausible claim for relief. The plausibility standard asks for more than a sheer possibility the defendant has acted unlawfully. Where a complaint pleads facts that are merely consistent with the defendant's liability, it stops short of the line between possibility and plausibility of entitlement to relief. Now again, the plaintiffs have alleged that each defendant individually acted willfully and maliciously toward the plaintiffs. Now, it doesn't allege a conspiracy or some other agreement amongst the defendants. It doesn't allege that any of the defendants forced another one of them to do something. The complaint doesn't even allege that Mr. Bertolino and the Laundries ever spoke about the statement before it was issued. It alleges all three independently had that heightened mental state to inflict severe emotional distress. Now, the plaintiffs have to advance that theory because this is an intentional tort. This isn't a negligence action where the Laundries are liable for Mr. Bertolino's negligence simply by employing him. Likewise, Mr. Bertolino is the one who made the statement. So he can't be liable if he didn't have the intent to harm. But that dictomy creates an implausible scenario. If Mr. Bertolino, as plaintiffs alleged, harbored such malice toward the plaintiffs to intentionally inflict emotional distress, to deliberately commit an act that goes beyond all bounds of decency, he would have been acting for himself, not as an agent, as an attorney for the Laundries. If Mr. Bertolino allegedly committed an intentional tort for his own purposes and not on behalf of his clients, then his clients cannot be liable for the acts of their agent, and the Laundries should be dismissed. And we cite the Diaz versus Associated Loan Company. It's 99 Southern 2nd, 279, Florida, 1957, which just says the liability of the master for intentional acts which constitute legal wrongs can only arise when that which is done is within the real or apparent scope of the master's business. It does not arise where the servant has stepped aside from his employment to commit a tort which the master neither directed in fact nor could have supposed from the nature of his employment to have authorized or expected the servant to do. If Mr. Bertolino harbored the mental state necessary to commit something so egregious, he could not at the same time fulfill his role as an attorney to the Laundries. It's hard to imagine a scenario where an attorney could commit an intentional tort and still be acting in his professional duty to his client. Making a statement that is utterly intolerable in a civilized society wouldn't be serving any client's interest. And if Mr. Bertolino, as the Laundries attorney, advised or even permitted his clients to issue a statement based on his own maliciousness, as the plaintiffs have alleged, then the Laundries could not have had the mental state necessary to commit the tort. They would have simply been allowing their attorney to act as their advocate, something that is not outrageous or to be regarded as atrocious and utterly intolerable. Now, if there is an obvious alternative explanation for the Laundries' activities, the court can choose the more plausible conclusion. Where the conduct is more likely explained by lawful behavior, the complaint does not plausibly allege a claim for relief. The most obvious alternative explanation is that this was a very upsetting time for everyone, and Mr. Bertolino was simply trying to express that without doing any harm to his clients. As his statement said, on the advice of counsel, the Laundrie family is remaining in the background at this juncture and will have no further comment. Now, Your Honor, in conclusion, the plaintiff's pain and frustration with how the investigation into Gabby's disappearance occurred is understandable. Absolutely. We all have sympathy for them. But as judges and lawyers, we know that almost every case, criminal or civil, involves some pain and frustration for the parties involved. Now, most of the time, not to the level of losing a child, but there is some discomfort. As humans, we have yet to craft a perfect system where everyone is protected, the victim, the accused, their families, but that would be impossible because everyone has rights. And often those rights butt up against each other. For that reason, we have legal guardrails to keep everyone involved in an investigation from being sued every time. While the plaintiffs deserve our sympathy, they just don't have a case against the Laundries. Thank you, Your Honor.
Thank you. We've been going for about 2 hours. Would anybody be objectionable to like a 5-minute break?
I would love a short break.
Okay, let's do that. Mr. Riley, you don't mind since it's your time to go next?
I was going to ask anyway.
Excellent. All right. Let's see you roll back. 3:35. Let's do 10 minutes.
Okay.
We have a lot of people in and out.
This is breaking news on the Hidden Killers podcast.
There is more to come. Part 2 is on the way in the feed. Stay with us.